and that day I was not well. So your Lordship fixed in this week, but this week it has not been listed. So may I pray your Lordship to list it on Tuesday, my Lord, so that it can be disposed of?
Tuesday,
Yes, my Lord.
18,
17.
18, Wednesday.
18 will be disposed of, my Lord.
Maybe, may not be, but 17.
18. Okay, my
We
Lord.
already
Thursday,
have
yes.
27 matters fixed. Yes.
Of light.
Yes.
18.
May I pray for the listing of a writ petition for admission? The urgency is that the matter was fixed for consideration of my interim term. It pertains to election of a few
Next
directors
week
of
is motion day. Already motion week declared.
the the difficulty which the petitioners are facing is while the interim period is was supposed to be considered on the next day, the cooperative society has convened a meeting on the 17th, your lordship, on which day the chairman and the vice chairman will be elected. Now, if these people who are inherently ineligible, if they are elected as the chairman and vice chairman, a further cause of action will rise, your lord.
When was it last listed?
It was last listed in the month of October, your lord.
Why did you wait for so?
No,
such a
because
long time?
the direction was to the cooperative registrar of cooperative societies to cause an inquiry and file an affidavit, your lord. So that affidavit, I have been informed that the inquiry is complete, but the affidavit has not yet been filed, and the matter was supposed to be listed after the affidavit is filed. And the notice for convening the meeting that has just been issued day before yesterday.
So the earliest it can be is on Monday.
On Monday, your lord. Deeply obliged.
Please, Your Lordship. Well, at last occasion, Lordship granted 1 week time to file additional affidavit and to be listed. Already I have filed the additional affidavit. Can it be on Monday? Admission.
Matter is not listed.
Not listed.
You mentioned it.
No, that is why I have come before.
No. Monday, all Monday.
No, please, Lordship. Forget to mention item 17, Lordship, supplementary list.
Yes.
We have instruction from petitioners not to press the case further, Lordship.
You are Mr.
NZ Chaudhary on behalf of Mr. A.R.P.
M.Z. Chaudhary,
Chaudhary.
counsel, petitioner on instruction subjects that the petition on which to press the petition any further accordingly and dismissed. That's not pressed in pre-order if any is delegated pending I also dismissed.
Wait, please, Your Lordship. Lordship, with the consent of the other side, petitioner side, Lordship, I beg to mention item number 34. Although the matter pertains to 2012, Lordship, here we had earlier filed an affidavit. This is a matter of illegal and irregular appointments, Lordship.
Yes.
And on the last occasion, Your Lordship has directed us to provide the particulars of the appointments of those petitioners, Lordship. So, the matter is also being investigated by the CID, Lordship, here. And in fact, by your order dated, your Lordship's order dated 2nd of May, there was a direction to obtain the status.
What is your prayer now?
Now, Lordship may fix after 4 weeks, Lordship, to obtain the complete instruction, Lordship.
Item 34 is the request of Mr. P.N. Sharma, Council Education, and adjourned to be listed after 4 weeks,
After 4 weeks, Lordship.
enabling him to procure the instructions as directed by the court.
Much obliged.
Next, please, Your Lordship. My Lord, I beg to mention item number 27. So it's the part of the series, my Lord. The issue involved is not similar. I have taken the consent of the other side, my Lord. They have, in this case, they have filed the affidavit in opposition. I need to file my reply, my Lord.
These are connected matters. Wait for the matter to be called. Yes.
Lordship, I beg to mention for listing of it. It's newly filed case. Matter
Newly filed will come on its own. It will come on its own if the defects are cleared. It will come on its own. You don't have to mention. Yes.
May I please, Your Lordship, I beg to mention one WPC, Assam Cooperative Society matter. During the course of election, at the time the anomaly was happened in the voter list. Some discrimination.
It will be in January now.
January 6, my Lord.
6, 7, we don't know. Give some date in January. Yes.
Maybe, Your Lordship. Not if you consider matters that I would like to mention item 12, Your Lord. I'm praying for adjournment of this case, Your Lord. So let me come up to vacating.
Item 12.
Yes, Your Lord. Hearing matter.
Yes. At the request of Mr. You're Mr.
PK Borala.
PK Bora. Counsel for the petitioner, matter stands referred to be listed after
Okay.
3 weeks.
Interim order.
Counsel for the respondent is also present. Interim order passed earlier will continue.
Apply, sir.
Just
Yes.
post office
Huh?
covered by
That 73-1 notice, madam, local notice has not been issued. Instead, madam, DRC 1 was issued, which we hold to be a so-called notice. That has been interfered with by the honorable court also. madam.
I have given the order of lordship, my lord.
All right, heard. And it comes to the part.
1 and 2, right?
1 and 2, my lord.
Respondent, Mr. B. Gogoi, appearing for respondent. Disposed of. Yes,
1 and 2 same.
1 and 2. All right.
Deeply obliged, my lord. Hey, please, lordship. Kindly pass over the time being. My seniors, next on number 19.
Notice be issued losses in this case. Matter that this is regarding my lord, the self permission. Some of the matter has been fixed on 17.
That notification.
Lot. So that my lord, that notice be issued, my lord,
No, it is fixed on 17.
17.
So let it come on 17.
Okay.
It is submitted by the counsel for the respondent that similar matters are fixed on 17.
7.
Therefore, let the matter be also listed on 17. Accordingly, matter directed to be listed on 17th. Yes.
No, please.
Yes.
So in a order that 11,
Yes.
2011, in page number 2, line in second paragraph, the measuring length 25 bigger 25 kotha is most of the a lot is typing mistake. It should be 25 bigger 4 kotha 0.3 lesser as per annexure 1 of the writ petition, my lord.
25 bigger
25 bigger 4 kotha 0.35 lesser.
0.35
lesser.
You're referring to this line 25 bigger 4 kota 0.35 lesser
Lesser.
KM
In
patta,
a line number
KM patta number 12
capital 12, dag number 30.
of Moza Gotana.
Moza Gotano.
Only this
Only this. Only this.
yes.
No objection, my. In fact, in earlier order, my lord, direction was then to consider the representation in respect of divisional forest officer matter. At page 10, my lord. Fourth paragraph. Forest is not there, but I have already. I have no objection to that.
All right, heard. Mr. Pathak, Learned Counsel for the petition by order dated 20/11/2024, passed in the PPT 7607 of 2023. Writ petitions to be disposed of with the direction to the divisional forest officer to call for records
Forest officer
and
declared.
actively consider to consider the representation, call for record, consider the representation, file with the petitioner and pass appropriate order within a period of 60 days. While dictating the order, the measure of land under KM Patta number 12, tag number 30 of the Monsa what Mosa is this?
Jalupari most.
Jalupari Muda of Kotanagar village was wrongly shown as 25 bigas, 25 kota instead of 25 biga, 0.4 kota and 0.35 kota. According this order dated 2024 stands corrected to the extent that the measure of land covered by KPA KM Patta number 12, tag number 30 of Jalupari Muda of Kotanagar village shall be read as 25 biga, 0.4 kota and 0.35 lecha in lecha. Stop. The IA is accordingly allowed and disposed of. This order passed today in the IA number 22 shall be read together with the order dated 2011-2024 passed in WPC number 7607 of 2020. I extend in terms of the above. Rest of the order, WPC 22 shall remain the same.
Well, this IA, my lord, under the my lord, unavoidable circumstances, my lord, this IA has been filed in the pending writ petition. One road, my lord, highway is proposed to be constructed on the land of the petitioner, and they have filed a writ petition. And this honorable court was pleased to issue notice upon the respondent. And order is, my lord, at page 83 and relevant portion page 92. The Lordship was pleased to issue notice page 92 on 27/11/2024, and thereafter, my lord, very recently, my learned friend from the government side took time in this matter, and this order I have also annexed, my lord, the relevant portion. I am directly skipping to this order, page 104. This is order passed by the Lordship on 9/12/2024, and the matter was fixed for further proceeding on 9/1/2025. This is at page 105, my lord, date is reflected. In the meantime, my lord, grievance of the petitioner is that Annexure A, page 28, notice has been issued. Very short notice, my lord, though it is a developmental work, my lord, and we are actually not opposing this road, my lord, but our, my lord, contention is that, my lord, without paying, my lord, compensation to the petitioners, my lord, and without proper demarcation of the land, this road is going to be constructed. And 3 days notice is issued, page 28, my lord. We are before your lordship against this short notice. Now, my lord, my humble prayer is that, my lord, road may be constructed, my lord, but as our, my lord, commercial shops are, my lord, standing there, my lord, admittedly, some time may be given, my lord, and road construction is maybe subject to the outcome of this petition.
Why should construction be subject to writ petition?
Because, my lord,
you are not challenging the acquisition. You are asking for compensation.
Compensation, my lord. Redemarcation, my lord, and de-identification, etc., is there, my lord, in our prayer, my lord. I have annexed, my lord, in the writ petition, I have quoted our prayer, my lord, page 6, my lord, page 22, and paragraph 6, I have quoted our prayer, my lord.
Yes, what do you say?
Strongly objected, lordship, for this. And because if minors may kindly peruse this order dated 10/12/2024, here it is rightly mentioned that so many times they have proposed, but their
10,
proposal
12,
has been
10,
dismissed, my lord.
10, 12.
Page 28 of this IA.
Ah.
Date, lord, 10/12/24. Here everything is clear, my lord. If lordship may kindly peruse this. With reference to subject cited above, it is intimated that
In spite of repeated communications, you have neither claimed the compensation amount nor vacated the land acquired for NHITCL project of Arzar Part 2 village. Further, in response to your application, several joint surveys have been carried out by the officials of the LA branch.
Compensation is lying there, you're not collecting it.
They are, my lord, only, my lord, for the entire market. They are giving us, my lord, compensation like less than, my lord, 300 square.
Then there is a provision for appeal, you go
They
there.
can approach the arbitrator, Lordship.
My lord, here problem is that, my lord, they are not properly demarcating the land, my lord. Actually, road is should go this way, my lord, and they are going that way, my lord.
What, how does it matter to you? You are concerned with the compensation.
Compensation, my lord, we are, my lord,
If you are agreed by the
demarcation, we are agreed, my lord. They are not properly identified.
demarcation, you are agreed, then you have to file a proper proceeding, praying for appropriate demarcation.
Therefore, my lord, we are praying for, my lord, before the concerned authority, my lord, for demarcation of the land, my lord.
No. Who is the concerned authority?
Deputy Commissioner, my lord.
So, where is the application?
Yes, my lord. We have submitted, my lord, application. Lot of applications are there, my lord.
So why have you not prayed for direction for demarcation of the land?
Yes, my lord. We are always, all our applications regarding our demarcation, my lord.
No, before the writ court.
No, my lord. Before the concerned authority, my lord.
I know, but if that is not done, then why have you not approached this court asking for a specific direction to cause demarcation?
Yes, my lord. This is our prayer, my lord. Page 22, my lord.
This is by way of a miscase.
No, my lord. I have quoted, my lord, a prayer of the writ petition, my lord. Only, my lord, my limited prayer is that, my lord, let their road be constructed, my lord. Sometime, because there are our shops are there, my lord. Some time may be extended, my lord.
No.
And the road construction may be subject to the outcome of the writ petition.
No.
Otherwise, my lord, writ petition will be infractuous, my lord.
If it becomes infractuous, it will become infractuous.
Then, my lord,
you are blowing hot and cold. If you are agreed by the compensation, there is a proceeding for that. If you are agreed by demarcation, you should have initiated a demarcation, the appropriate proceeding before the appropriate forum. And if you say that in spite of approach to the authorities, no action has been taken, you could have approached this court.
Therefore,
now you are challenging this notice where it is clearly
directly,
stated.
my lord, we are, my lord, praying only, my lord, to save our, my lord, prospect of our writ petition, my lord. Because as they are, my lord, demolishing our, my lord, shop, my lord.
We are not inclined to consider your attempts to save the writ petition.
Yes, well, otherwise, my lord,
we will save your writ petition only if we find there is a legal right infringed.
My lord, our, my lord, because, my lord, having, my lord, being prima facie satisfied, this honorable court, my lord, notice is issued, my lord, and matter is fixed, my lord.
We will hear it as and when it comes.
So, my lord, if what I am praying, my lord, nobody will be harmed, my lord, because only they are giving time 3 days, my lord. Some time may be extended, my lord.
What is your prayer in the writ petition?
My lord, prayer of the writ petition, my lord, page 22, my lord.
Let us see the writ petition.
Is therefore most respectfully prayed that your lordship may be pleased to admit this petition, call for the record, issue rule calling upon the respondent to show cause as to why the appropriate writ order or direction shall not be issued, directing the respondent to resurvey and redemarcate the land of the petitioner properly under patta number so and so, dag number so and so, village so and so, as per their land records, documents, etc., and to pay due monetary compensation to them in accordance with law. Only for the entire market, my lord, they are showing, my lord, only 1 or 2 lesser land are they are acquiring, my lord. Because of their, my lord, wrong, my lord, demarcation by the Mondal, my lord. Therefore, my lord, time and again we are praying before the and all the
asking for due compensation.
Yes, my lord. Because they are, my lord, not, my lord, adequately, my lord, demarcated our land, my lord, they are Therefore, my lord, they are showing a nominal, my lord, land.
That there is a different proceeding that you will have to go. We can't decide on the specifications of demarcation in this proceeding. You are aggrieved by adequate compensation. That we'll see.
Only, my lord, they have said, my lord, our land. Lordship, kindly have a look page 103 in the writ petition.
How much time do you want?
1 month, my lord, time enough.
1 month.
Yes, my lord, they have to vacate their shop, my lord. They are
Vacate it. They'll vacate it by 31st December.
Well, the matter is fixed, next date is 9th of January, the main.
So they'll vacate in the IA.
Right.
We'll dispose of the IA, directing them to hand over the possession by 31st December. All right?
December, my lord, they have only 1 month time maybe.
Why?
From today, my lord. Only.
Why 1 month?
My lord, because they are on their old shop, my lord.
31st December is still more than 15 days.
Only
You
1
have been
month.
given 3 days to vacate. We are giving you more than 15 days.
Kindly 1 month from today, my lord.
No. Either take it or we dismiss it. All right. Heard Mr. A.M. Borbhia, learned counsel for the petitioner, Mr. P.J. Talukar, learned senior government advocate, MS V.L. Singh for PWD, National Highway. His IA has been filed by the petitioner seeking uh, to set aside and quash the notice dated 10/12/2024 issued to the petitioners to vacate the portion of the land which is required for NHIDCL project at area Dhar Part 2 village. So the learned counsel for the petitioner submits that his notice was served on 10/12/2024 and only 3 days time has been granted to vacate the said area. So he submitted that the petitioners have business establishments in the said area, but the same cannot be vacated within 3 days. Therefore, his IA has been filed seeking, praying for further time. So the further grievance of the petitioner is that the demarcation by the PWD authorities is not properly done, and as a consequence thereof, the compensation which the petitioners are entitled will has been wrongly calculated. So, Mr. P.J. Talukar, senior counsel, is appearing for the state as well as MSPL Singh, standing counsel PWD, National Highway, strongly opposes the prayer made in the IA. So, the counsels refer to the notice dated 10/12/2024 in Annexure A to submit that the notice itself is very clear that the applicant petitioners have not claimed the compensation amount, nor have they vacated the land required for an NHDCIL project at the area Dhar Part 2 village. So, they submitted that if the applicants are aggrieved by the quantum of compensation, then appropriate procedure prescribed under the statute may be resorted to. So, the notice further reflects that repeated communications have been issued by the office to the petitioner and they have failed to respond. Consequently, the notice dated 10/12/2024 was required to be issued so that the construction of the road under what project?
National Highway.
NHDCIL project can be proceeded with in a time-bound manner. Where learned counsels for the parties have been heard, pleadings on record have been carefully read. It is seen that the writ petition namely WPC 6188, is pending, where court has issued notices and the respondents are yet. Have you filed any response?
No, not.
Respondents are yet to
We have been
submit their
granted time till
reply.
9.
Stop the matter is 6th or 9th of January. Stop. No interim order was passed while issuing the notice in the writ petition. Stop. Insofar as this IA is concerned, the IA is directed against the notice dated 10/12/2024. The notice clearly reflects that the petitioner has not claimed the compensation amount nor vacated the acquired land for any IBCL project at the area Jhar Part 2 village. Stop. There is no dispute that the acquisition proceedings initiated by the respondents are not under challenge. So, what is under challenge is the quantum of compensation on the basis that the demarcations have not been properly made. Stop. This is the issue which is pending in the writ petition. Stop. Insofar as the notice is concerned, uh, since it is already reflected in the notice that the petitioners have not claimed their compensation, this court is not inclined to grant any orders of the IA in respect is not inclined to grant any orders in respect of the prayers made in the IA. Stop. However, considering the fact that the notice has been issued directing the applicants to vacate their premises within 3 days, this court is of the view that ends of justice will be made if a direction is issued to the petitioners to vacate and hand over the possession of the land to the respondents on or before 31st of December 2024. If the respondents, if the petitioners do not vacate the land, then the respondents are at liberty to take appropriate measures as prescribed under law. IA accordingly stands disposed of in terms of the above.
And my lord, that may
Writ
be
petition to be
subject to the
discussed on 9th of January.
subject to the outcome of the repetition. We will, my lord, hand over the possession subject to the outcome.
We have directed you 31st December.
It's okay, my lord. The land will go, my lord. We are also, my lord, cooperating with the road, my lord. But if our land is gone, my lord, under the road, my lord, then we should get our compensation.
It is ready, you go and collect it.
No, my lord, they are, my lord, saying that only, my lord, 2 or 3 lesser land are going, my lord.
You are aggrieved by the quantum of compensation. There is a procedure laid down. Why not taking recourse to that?
My lord, our prayer is that, my lord, basically the writ petition, my lord. Compensation, they will give, my lord, and giving also, or notice is also issued to receive compensation. But our, my lord, contention before your lordship is that, my lord, they are, my lord, adequately not demarcated the land, my lord.
We'll hear that in the writ.
Therefore, my lord, only to one observation, my lord, land is gone, my lord, we are cooperating, my lord, subject to the outcome of the writ petition, my lord.
What is subject to
My lord, thereafter, my lord, land will be demarcated, my lord. If we are, my lord, entitled, then we will entitle, my lord.
be taken care of in the writ petition.
Therefore, my lord, one observation may be necessary, my lord, because once, my lord, land is gone, my lord, it will, my lord, nobody will be prejudiced, my lord, with this observation, my lord. Your lordship already given the land, only subject to the outcome of the writ petition, my lord.
What is not possible this side, don't try it to the other side. Right. So we have given you the protector in the writ petition. Whatever orders are there, try and to hand over the land by 31st. All right.
Then road should go, my lord. We are also not objecting, but we should get our, my lord, adequate compensation if our land is taken.
You are entitled to challenge it if you don't get. All right.
Obliged.
Yes.
Lordship has already decided day before yesterday the party regarding party law.
We have not decided. It is fixed on 19th.
Now, your lordship may kindly come to agreement
17th or
matter.
19th. I'm not sure.
Your lordship, I am coming to the agreement, my lord.
I think over it.
Page 40, my lord.
Yes.
Page 42, my lord. I am coming to the agreement.
So 42.
Yes, my lord. Articles of agreement made this 12th day of March 2020 between the President of India acting through the Railway Administration, hereinafter called the Railway, on one part, and the Bharatiya Infra Projects so and so, herein called the contractor of the other part. This is very important, madam. Now, whereas the contractor has agreed with the railway of the performance of the work for earthwork, construction of major bridge, minor bridges as per bridge list attached, and protection work between chainage number so and so in connection with the construction of Jiribam Tupul Imphal new BG railway line project set forth in the schedule annex herewith upon the general conditions of contact and specification of the Northeast Frontier Railway 2018 edition. Now, I am coming to the agreement. I am coming to the section, my lord. This section 2, my lord.
Arbitration.
Arbitration.
Yes.
My lord, it starts section 2, my lord, in this part, unless the context otherwise requires. Now, your lordship may come to section 2H. Party means a party to an arbitration agreement. Now, what is the arbitration agreement, my lord? This is defined in section 7, my lord. Section 7, my lord.
Yeah.
In this part, arbitration agreement means an agreement by the parties to submit to the arbitration all or certain dispute which have arisen or which may arise between them in respect of a defined legal relationship, whether contextual or not. And now, your lordship may kindly come to section 21.
Yes. '21. Yes.
21. Commencement of arbitral proceeding. Unless otherwise agreed by the parties, the arbitral proceeding in respect of a particular dispute commence on the date on which a request for that dispute to be referred to arbitration is received by the respondent. Here the word party is not there, my lord.
That's right.
Yes. Now I am coming to, my lord, the arbitration agreement. What is the arbitration agreement, my lord? This clause 63, 64 is the arbitration agreement, which is at page 52, my lord. The entire agreement cannot be said to be arbitration agreement, my lord.
Yes.
Now arbitration agreement at page 50, 51, my lord. Clause 63.1. Matters finally determined by the railway. All dispute and differences of any kind whatsoever arising out of or in connection with the contract, whether during the progress of the work or after its completion, and whether before or after the determination of the contract, shall be referred by the contractor to the GM, and the GM shall within 120 days after receipt of the contractor's representation make and notify decision in all matters referred to by the contractor in writing, provided that the matters for which provision has been made in clause number so and so of standard general conditions of contract or in any clause of special conditions of contract shall be deemed as accepted matters not arbitrable. And the decision of the railway authority thereon shall be final and binding on the contractor, provided further that accepted matters shall stand specifically excluded from the purview of the arbitration clause. Demand of arbitration. In the event of any dispute or difference between the parties hereto, as to the construction or operation of this contract, or respective rights and liabilities of the parties on any matter in question, dispute or difference on any account, so as to withholding by the railway of any certificate to which the contractor may claim to be entitled to. Or if the railway fails to make a decision within 120 days, then in any such case,
Where is the definition of a contractor here?
yes, I am coming. This is now in this case, my lord, GCC 2018 is applicable.
Huh?
Now, in the definition of contractor is defined in the GCC, which is part and parcel of the contract agreement.
It's not a part of the pleadings.
It is there. It is already there.
Okay, page number.
No, here it is and there in the GCC it is there. Definition is provided in the GCC.
That's right. Whether the GCC is a part of the pleading.
No, not part of the pleading.
So then show us, give us a copy.
Yes, I will give the copy.
GCC as in general conditions.
General condition of contract. In each agreement, separate general conditions of GCC is there. On the top, my lord.
Yes. अरे एक नहीं वो सारे देखिए. Yes. Clause G.
Yes.
Clause G.
Contractor definition is there. So it includes the agent also.
Yes.
And as your lordship aware about the Perkins judgment, my lord.
No, but I am surprised that you are not referring to a judgment which was rendered in one of your matters.
Yes, this
by
is
this court.
It is also there, my lord.
That is on this
Yes, it is
particular
also
point.
When there is a coordinate bench judgment, my lord, where it has already been decided.
Yeah.
And there is a Rajasthan High Court judgment also, where this matter was considered, the definition of party. Main thing is, my lord, in context, in what context the party is to be referred. The context relating to section 31, 33, and 34 is different.
Have you given him a copy of the judgment?
No.
Give him a copy.
And may I read one paragraph of the Honorable High Court judgment, madam?
Yes.
Having scanned the material on record, I am prima facie satisfied that the conditions laid down by the Honorable Supreme Court are met in the present case. Inasmuch as the petitioner is a party to the arbitration agreement, there is an arbitration agreement and there is contract between the petitioner and the respondent. 1 and 2 and respondent number 6 had knowledge of the contract. Russell, an authority on the law of arbitration, also indicated as to who are the parties to the arbitration agreement. The observations of Russell 19th edition at page number 69 are relevant that reads as under. Parties to the arbitration agreement, an arbitration agreement will bind not only the actual parties to it, but also an assignee of a contract containing it, the personal representative of a deceased party, a trustee in bankruptcy who adopts a contract containing it, and general all persons claiming under any party to it, but not a stranger to the agreement. So any party claiming under any of the party will be coming under the definition of the party.
Which paragraph you're reading?
This is relating. This is Rajasthan High Court judgment. And your lordship is aware about the Perkins judgment, my lord. One maxim is adopted. This is related to the section 11 petition, my lord. Maxim is that what one does through another is done by oneself. To put it in another form, that which cannot be done directly may not be done indirectly by engaging another outside the prohibited area to do. So whatever the advocate is doing on behalf of the contractor, my lord.
And what is this judgment you are referring? Ravi Ranjan?
This is related to the context. This is about the in what context one judgment has been delivered. This is relating to that.
You are referring to Perkins.
Yes, Perkins.
Paragraph?
Paragraph 51, my lord.
Question to the president. 2020. 20 is 5760.
I am referring, my lord, this maxim which is adopted by the and accepted by the Honorable Supreme Court.
Yes, Mr. Roy. Lordship. There's a courted bench judgment on this issue.
I have seen lordship. I am relying on 2012 9 SSC, but it was coordinate benches. Lordship.
That is discussed.
Discussed here, lordship.
You go through the judgment.
Lordship.
I think it is on this issue.
Only this issue.
All right.
My lord, this is Rajasthan High Court judgment.
The other matter is fixed on 18th, so we are keeping this on 18th.
This month, my lord.
Huh?
This month.
Yes.
I have some problem with it.
You're available on which date?
My lord, on only up to Saturday I am available. This item may come up, my lord, on 9th Jan.
All right. No, but forget that is the whole problem. When do you want it? 9th?
9 January, any date.
9 January. All right. 9 January.
No.
This is all. This interpretation is not even called for in view of the definition of the GCC.
Yes, sir.
So
no more
interpretation
yes,
is necessary.
authority is
Part of the
required by
GCC.
Yes, because we cannot go against the terms of the agreement.
All right. Third learned counsel for the parties, Mr. Robinson, Mr. Adversary, has a matter be listed on 9th of January. You go through it and see if there is any further submissions you'd like to mention, render. Please take
May I please? Malad, this writ petition, Malad, in a limited prayer, Malad, Lordship kindly see page 16. He has filed, Malad, several applications. Page 16, Malad. 1-6. Praying for demarcation of a particular plot of land that has not been done by the respondent authority. That is the Malad limited prayer. Page 16. Now, my learned senior counsel, Malad, has referred the notification in which I have to file a Malad application with in a prescribed form. I will file the Malad application in the prescribed form, Malad, and Malad, let them direct to Malad make demarcation within a certain period of time, Malad. That can
In the notification itself, it is stated that in a period of 30 days.
Where have you mentioned in the affidavit that it must be in a prescribed form? In the affidavit?
No, Lordship, in the affidavit, we have filed an affidavit pursuant to the direction passed by the Honorable Court. Order dated 25/9/2024.
That says, Malad, our land measuring.
Road has been found.
Yes. 1.5 lessa has been used for the construction of the road. And rest of the
Pursuant
land.
to that direction, Lordship, we have filed our affidavit whereby it was found in page 22, annexure A. So it's a patta land, Lordship, wherein the land was constructed by the Gaon Panchayat. But now my learned friend is praying for demarcation. That is why I have not.
Where is that circular or notification?
Lordship, this is.
I heard this petition is directed, it's filed by the petitioner with the specific demands that in spite of representations filed, the land in question belonging to the petitioner covered by Act number 176, Patta number 45 of village Korea.
Korea. Pardon. Page 16, Lordship will find.
North or south? No, you said Korea, is it north or south?
Korea part 1.
Korea part 1.
Korea part 1.
Kamari Revenue Circle, District, Onegao. Assam. Stop. An affidavit was filed by the circle officer pursuant to directions of the court, where there is a specific averment that upon verification of the claim of the petitioner, it has been found that a road has been constructed over a portion of the land measuring 1.5 lecha out of the land measuring 2 kota 10 lechas covered by Patta number 45, Dak number 176 of village Korea, part 1 under Poitamari Revenue Circle. Stop. The affidavit also specifically makes a statement that the petitioner is the pattadar of the same plot of land. Stop. Mr. H. Sharma, learned counsel, government counsel, appearing for the respondent, submits that as per office memorandum number 2 and so dated 21st of December 2020, the government has issued a set of by the said office memorandum, the government has laid down the manner in which applications seeking demarcations are to be filed by the affected parties. So, the procedural steps for issuance of demarcation certificate is also laid down in the same office memorandum. Stop. The office memorandum also specifies a user charge required to be paid by the applicant. Stop. Learned counsel for the government counsel submits that the petitioner may file a fresh application in the criteria and the format laid down as per Office Memorandum 21st of December 2020, and thereafter the authority will take necessary steps for issuance of a demarcation certificate. Correct. The submission made by the Government Council is not objected to by the Learned Council. Stop. Mr. Mondal submits that he would approach the which authority? Circle officer. Circle officer. Boitamari Revenue Circle.
District Commissioner, Lord.
Huh?
He has to make that application to the District Commissioner, Lord.
With circle and circle is no correct and DC.
Application form
Circle officer. No correct then DC.
The petitioner will file the application for demarcation in terms of the OM dated 21st of December 2020, and by paying necessary charges, and thereafter the respondent authority will proceed to demarcate the land and pass and necessary orders and issue the necessary certificate within a period of how much time do you require?
Time.
30 days.
Let it be 60 days.
60 days. From the date of receipt of a certified copy. From the date of receipt of the application, fresh application that will be filed by the petitioner, along with a certified copy of this order. The petition accordingly disposed of in terms of the order.
Deep Lord bless it. In this case, Lordship, we have been directed to file an affidavit, Lordship. From the circle office, they are praying for some more time, Lordship. May I pray, Lord?
Yes.
So I'm praying for some more time, Lord.
In the writ petition.
In the writ petition.
There is also an IA.
IA was filed by the private respondent for vacating the stay. So that on the last occasion, your lordship has observed that it will be hard together.
Okay. Heard learned counsels for the party, Mr. H. Sharma, learned additional government advocate, senior government advocate, submits that he has received instructions to file a counter affidavit. He prays for 3 weeks' time.
Sure.
Mr. A. Roman appears for the private respondent, and as well as the applicant.
21st February.
The applicant is the IA number 048.
25th,
Let the matter be listed again
on 24th of January, Lord.
24th of January.
Well, there is an interim order that may be.
Interim order passed earlier will continue in the next 8 days.
Obliged.
May I please, your lordship? Lordship, a week's time may be granted to file our reply, your lordship. We have
Petitioner prays for further 1 week time to file the reply. Prayer not objected.
maybe listed immediately after vacation.
January on the date. Yes.
This matter may kindly be taken along with my lord, other connected matters, my lord. Service tax.
When is the matter picked?
Today, my lord.
Oh, okay.
Item number 24 onwards.
Yes.
This is the matter, my lord, that your lordship had heard on that day.
The day before yesterday, the matter was listed before your lordship, and I was supposed to inform this honorable court whether the petitioners have got the relief or not, that compensation, that compensation. Lordship, after going through the record, it's a voluminous report, lordship. So I need some time, lordship. Kindly, picture for list
No,
of
my lord, last
2200.
again, lordship, court has verified them that not to take further time, because my lord, issue is, my lord, I'm confining only to direct process method they have adopted, my lord, in contrary to the government
How
guidelines.
much time do you require?
At least 1 week time, because it's a 1543 persons list. I
Well,
have to verify each and every.
My lord, issue is, my lord, only confined to the notification, they have to adhere to the notification. Lordship may dispose of directing them to reconsider committee as per the notification, my lord.
Every time, my friend.
Let them answer to the court's query whether
Yes,
any compensation has been paid to not. If we are supposing some of you have received the compensation.
No, my lord. My lord,
let us say after verification it is found one to whatever person received. And if you still insist on reconstitution, then you'll have to give back the compensation amount.
yes, my lord. My lord, thing is that, my lord, they have to show as per the notification they have adopted, state government has directed them to pay the compensation. We are saying, my lord,
I think on the last occasion you had submitted that some of them have received compensation.
he has submitted, my lord.
Yes,
sir. You have submitted.
Yes,
Because
yes,
it's a volume. You identify those numbers and give it to us.
Definitely,
When can you do it?
At least 1 week time, because it's a voluminous list of 1543.
My lord, in the meantime, they should not, my lord.
All right, 7 January.
No.
7 January.
7 January, my lord.
There is no calendar there.
Tuesday.
Calendar nahi?
Yes, Lordship. 7th January, Tuesday, Lordship. Yes, Lordship.
My lord,
there is no calendar there.
Yes, my lord. There is.
There is, Lordship.
Half is torn, my lord.
मैं बोला लगा एक प्लास्टिक में डाल देते हैं।
Well, I found here.
7 January.
Well, in the meantime, they should not take any coercive against us.
Nothing.
Our children and my lord, the families are there, my lord. They at least they have to show today, my lord.
The learned council appearing for the Demarcation for further time, verify the report to ascertain and submit to the court whether any of the petitions have been granted the compensation for acquisition for the land sought to be acquired. In whereas counsel for the petitioner strongly submits that no compensation has been received by any of the
No, compensation has been received on. We have till now we have been able to find out 4 number of persons of the serial list. That is serial number 5.
Number of the writ petitioner.
Yes, Lordship. Some of that.
No, we are recording his submission.
Lordship.
Accordingly, let the matter be listed on 7th of January, on which date the standing counsel, Mr. R. M. Dal, will furnish to the court complete list of least, if any, of the petitioners who have received the amount.
It's per day, my lord.
Well, if the next date we take no coercive action initiated against the petitioner without legal.
As per my lord, annexure 1, and the affected villages.
Whatever it may be, no coercive action in respect of the land in question.
In respect of land,
Yes.
Lordship, my
In respect of the land in question. Lands in question.
obliged.
Yes.
Lord, in this case, last occasion, our respected senior counsel has discussed about the alternate remedy. I adopt the same argument on this case. In addition to that, there are certain other arguments are there
filed in the written form. My lord, in this case, it is a related limitation. This case has been issued, token issued after 5 years, 25 days. Whereas, as per section 73, maximum period is 5 years. Thereafter, no token will be issued.
Propose is issued after
5 years, 25 days. Maximum period is 5 years. Even in case where there is a suppression effect or intentional evasion effect.
5 years, 25 days.
Yes.
Yes. That's all.
Yes. And this is all activities are exempted activities. Provided that is also mentioned. All activities carried on by the appellant petitioners are pertaining to railway construction, that is exempted, and no tax is liability.
What activities were you carrying on?
Activities is digitalization of signal system in replacement of the old system in the railways.
Activities in the
Digitalization in railway signal system by replacing the old analogical system applicable in the system.
That's all.
And for item number 25, my lord. So apart from the argument placed by the senior counsel, only I like to submit the facts of my case in the written form.
You have to furnish a copy to the respondent also.
Yes. So far as item number 33, 31, 28, and 29, your lordship. Learned senior counsel have already advanced. We will file our written argument. So far as item number 21, my lord, same issue is there. It is also based on 26 AS. So it may be tagged with
item number
21 also. It may be tagged.
Yes.
So, my lord, we will file our written argument. Learned, we are going to. What my
He will file. Yes.
Item number 27 is concerned is not similar to the series, my lord. They have in this item they have filed a affidavit in opposition. I need to file my reply. I am paying for 1 week time only.
What reply? We are hearing the matter.
So
Whatever
that-
you want to submit, you submit now. No further time for reply. We have already started the
It
hearing.
is not based on 26 AS, my lord. The issue is different. That's why, my lord. In those cases, my lord, the issue was with regard to.
Whatever it may be, you submit. You argue. We are proceeding on the hearing. You want to now file a reply.
No, my lord, it is not similar. It was series.
What is the issue about in your case?
There are two issues, my lord. First, I'm touching the little facts, my lord. And here, my lord, Sokoj was issued, my lord. That a personal hearing took place. The petitioner was supposed to file the written submissions, written reply. In the meantime, what happened, my lord, the chief accountant of the petitioner, my lord, whose brother fall ill and his brother passed away. So he could not submit the reply. he submitted a reply on 7/2/22, my lord. In the meantime, order was already passed and order was communicated on 9/2/22. The order was passed because the fact that there was no reply, therefore, the order was passed. One thing is that if the lordship may remand the matter, my reply is already on record. If they can consider and pass fresh order, it can be done, my lord. Otherwise, my lord,
It was rejected on the ground that you did not reply.
did not reply. So personal hearing was took place. We took time to file reply, written reply. In the meantime, my lord, the chief accountant's brother, who fall ill in the month of December, he subsequently succumbed to his illness and he passed away. The reply was submitted, my lord, on 7/2. However, and the order was already passed and it was communicated on 9/2, my lord. The reason is that there was no proper reply in the on record. As on today, my reply is there, my lord. If they can consider my reply and pass a order, it will suffice, my lord. Otherwise, the cable operator, my lord, what happened, my lord? He is a multi-cable operator, my lord. He used to give signal to local cable operator. He charged 74 rupees per consumer. And local cable operator charges 200 rupees from per consumer. Now, department is of the view, my lord, that 200 is charged by this petitioner. But now there is nothing on record that 200 was received by the petitioner. The petitioner received only 74 rupees, 74 per operator. Then therefore, his liability is to pay tax on 74 rupees per cable operator, my lord.
You satisfy that? On what materials do you satisfy that?
My lord, my balance sheets are there. They have gone beyond the balance sheets, my lord. My figures are there. They have gone beyond the balance sheets.
On what basis have they decided on this issue?
Now, they decided on the issue. They went into an investigation, my lord. They recorded some statement. The statement has misinterpreted, my lord. It is on record, my lord.
Yeah.
I have also annexed the agreements which says, my lord, we will charge only 74 rupees, my lord. My lordship may kindly come to page number 54, my lord. This is one of the agreement, my lord, between the cable operator and local, this present petitioner and local cable operator, my lord. In page 54, my lord, it is clearly mentioned that, my lord, we will be charging 74 rupees per boxes, my lord. And they can charge, my lord. And we have also annexed the bill at page 71, my lord. We have charged rupees 74 only, my lord. If they can consider a fresh, my lord, my case, then, my lord, perhaps there is no liability, my lord. And my reply is on record only. If they can.
We'll examine that.
My lord.
That is your only what reply you want to file now?
Reply is there already. My lord, reply was filed.
No, you said you wanted to file a.
They have filed their affidavit in opposition, my lord.
So to what effect are you going to file a rejoinder?
In the even if reply is also not required, because in the affidavit in opposition they have said, my lord, since I have not submitted so-called reply, therefore findings are correct. They are saying, my lord.
That's right. You did not submit within the time specified.
That is true, my lord. Because the reason I have given, because the chief accountant's brother, my lord, he followed. I have another death certificate.
Show us some authority that a statement that your chief accountant is fallen ill is enough to extend your time or interfere with
My
the
lord.
order passed by the authorities concerned.
Then now second question come, my lord. Consideration, my lord. I am liable to pay service tax only on the consideration received per section 67, my lord. So, my lord, my consideration is rupees 74. They have come to a presumption that the amount received by the local cable operator is chargeable to service tax. So, my lord, however, my consideration is rupees 74 only. I am liable to pay service tax on 74 that I have paid, my lord. Now they want to say, my lord, since I am the main cable operator, therefore the liability will be on my mind. But it cannot be, because my consideration is 74 only. I am operating from Dibrugarh. I am supplying signals to different districts, my lord, in Sukia, in Sipsagar, everywhere. They are local cable operator who, my lord, who collect money, who charge money from the consumers, my lord, at the rate of 200. And some of the local cable operator are, my lord, registered SSC of service tax. They are paying service tax also, my lord. My lord, 200 rupees, I cannot be, my lord, held liable for paying 200 rupees, my lord, on 200 rupees, my lord. Because from the bills I have annexed, my lord, I am charging 74 rupees only.
You are charging it on whom?
On local cable operator.
On the operator.
Operators, not on the consumers, my lord. Therefore, my liability will be on the amount which I have charged. A few copies of bills I have annexed, my lord. Page 71 is one of the bill, my lord. From it is clear that I am charging 74 rupees only from the local cable operator, not from the consumer, my lord.
All right. Then no reply is necessary. If you want, you can give your written submissions.
my lord.
Yes. Anyone?
Your Lordship, item number 32. Similar matter, we adopt the submission of Dr. Ashok Sharaf sir, and we will file our written submission.
Yes. Yes.
Item number 30, so far as item number 30 is concerned, Lordship, we adopt the argument of Dr. Sharaf. Lordship, additionally, I want to point out only two things. Firstly, Lordship, my order of assessment is barred by limitation. And Lordship, there is a circular, Lordship, by the department itself. I just want to place that circular. That's the only additional argument I want to make, Lordship.
30.
Lordship, the Lordship.
What is your item number?
Item number 30, Lordship.
30. 30. Yes. What do you want to say?
Lordship, circulars, Lordship, normally are Lordship, the circulars are binding on the department, but not on the SSC. Lordship, page number 7, if your Lordship may kindly see. Lordship, the circular has laid down what is the meaning of, Lordship. In fact, page number 6. Page number 6, point number 3.2 and 3.3. Lordship, what has happened is that, Lordship, the Lordship in under the Finance Act 1994, Lordship, they can Lordship within 30 months they can pass the order of they can issue the so-called notice. Lordship, but they can issue the notice for the extended period of 5 years if they can invoke the extended period of Lordship limitation. Lordship, what are the ingredients for extended period? Lordship, may kindly see at page number 3.2, which they themselves have laid down. This is their own circular, Lordship. And my Lordship, so-called notice, and in all the cases, the so-called notice have been issued after this. Lordship, 3.2 ingredients for extended period, Lordship. Extended period can be invoked only where there are ingredients necessary to justify the demand for the extended period in a case leading to short payment or non-payment of tax. Honors of establishing that this ingredient are present in a given case is on the revenue. They have themselves said. And these ingredients need to be clearly brought out in the so-called notice along with evidence. The active element of intent to evade duty by action or inaction needs to be present for invoking extended period. Secondly, Lordship, they have relied on apex for judgment of cosmic dichemicals, which says, now so far as fraud and collusion are concerned, because Lordship, the extended period of limitation can be invoked only in case of fraud and collusion. And so far as fraud and collusion are concerned, it is evident that the requisite intent, that is intent to evade duty, is built into these very words. So far as misstatement or suppression of facts are concerned, they are clearly qualified by the word willful. So it has to be willful. It cannot be that they can say that only fraud and misrepresentation is there. It has to be willful. That is the judgment of the Supreme Court which they have relied on, provided preceding the words misstatement or suppression of facts, which means with intent to evade duty. The next set of words, contravention of any provisions of this act or rules, are again qualified by the immediately following words, with intent to evade payment of duty. It is therefore not correct to say that there can be a suppression
So
of this.
essentially, you're saying that there is no fraud or collusion, so therefore the extended period of limitation ought not to have been.
Cannot be. That is the Lordship, my main submission. And Lordship, they have invoked the extended period of limitation in my case by, Lordship, may kindly see only one paragraph I will refer to in my order. Lordship, at page 110, 4.4. That's the impugned order. Item number 30, Lordship. Page 110, 4.8, Lordship. I find, Lordship, have your Lordship got it?
Yes.
I find that the noticee filed ST3 returns for the period so-and-so on 21/10/2016. Thus, the relevant date for the purpose of determining limitation period under section 73 of the said act is 21/10/2016. In view of the above, thou the present SOCOS notice 22/10/2021 appears to be beyond the period of 5 years. So my Lordship, SOCOS notice was beyond the period of 5 years. They have accepted. But stipulated under provisions of section 73(1) of the said act, in terms of the order dated so-and-so passed by the Honorable Supreme Court. So let's say that COVID period they have invoked. Otherwise, they have accepted the fact that it is beyond the period of even 5 years. Extended period they have not invoked. In fact,
where have they stated?
Lordship, paragraph 4.8, Lordship, may kindly see again. I find that the noticee filed their returns for the period April 2016 to 17 on 21/10/2016. Thus, the relevant date for the purpose of determining limitation period under section 73 of the said act is 21/10/2016. In view of the above, though the present so-called notice dated 22/10/2021 appears to be beyond the period of 5 years stipulated under provisions of section 73(1) of the said act, in terms of the order dated so and so passed by the Honorable Supreme Court in this case, Lordship, that 3 of 2020. They have invoked that because it was COVID. So we are invoking the extended period. This is the reason they have given. 5 years, even though
They're
it is,
entitled to.
Lordship, I am
They're
just pointing out
entitled to.
that even after 5 years, but Lordship, my limitation period is 30 months.
So your argument is that there is no fraud or misrepresentation or suppression.
So that
Therefore,
it can
the
be
extended
extended.
period of 5 years is not there.
Extended
The
period of 5 years.
reference to Supreme Court judgment, how is it relevant?
Lordship,
They're
Supreme
entitled to, anyone is entitled to. if
Yes,
they want
Lordship. That is my Lordship humble submission, and their circular is binding on them. They themselves have Lordship. And it has to be willful, Lordship. That is only one word also I want to, that not only fraud and represent, that has to be willful. That is what their circular says. That is my humble submission. Otherwise, Lordship, I adopt my argument of my learned senior. Much obliged. Lordship.
I'm appearing on in case number item 26.
26.
20. Senior counsel Ken Chaudhary is engaged in the case. He has some personal difficulty today.
Can we help? We are hearing the matter.
Tuesday it may be. Tuesday.
No. We are already
He's
hearing
out
the
of session.
matter. Huh?
Today he's out.
Is there
We'll
anything
finish
new
our
to be argued?
Tuesday.
Is there anything, what is your ground?
We'll file the written submission then.
Huh?
We'll file written submission.
All right, Tuesday. If you want it on Tuesday.
Tuesday.
All right. Yes. Anyone else?
I'll file a written submission.
Mr. Kyal?
Beside the argument of merit of this case, one of the petitioners submitted his written with another said yet to be filed. So after getting that, my first argument is what if there is a alternative.
You'll be arguing which matter? All the matters separately?
Separately, I'll file my written argument on the basis of inputs supplied by the petitioner, because only one petitioner has submitted his written argument. That's it, not separate. So beside this, my common argument is that it's petitioner are barred by alternative remedy. Recently, Lordship Honorable, our High Court on 7/8/2024 passed an order with respect to GST matter, Lordship, but it is also applicable here. Paragraph 10 onward. Page 10. GNRC Limited versus Union of India.
Yes.
With appeal number 254/2024.
Yes.
We have heard the learned counsel appearing for the parties peruse the interim judgment and materials available on record. The case set up by the appellant company before the learned single is that they have paid taxes in excess inadvertently due to ignorance and lacks clarity the provision of law. The upfront claim of the appellant company before the respondent were rejected by the extent commissioner PhD Central Access Guwahati by passing the order on different dates. We could have gathered from the pleading that when the appellant company had challenged the state so-called notice as well as the order whereby the refund claim had been rejected, we are of the view that after issuance of the so-called notice, when the final order is passed by the authority concerned, essentially the writ petition filed by the appellant company against the order, whereby the refund claim applications were dismissed. The learned single judge has opined that against the rejection of the refund claim, the appellant company has alternative remedy to file appeal under section 107 of the CCC Act. Even if assumed that the writ petition filed by the appellant company do not involve any specific question of fact and purely question of law have been raised, then also the question arises whether the learned single judge has committed any illegality in refusing to exercise discretionary jurisdiction under Article 226 of the Constitution. It is true that Honorable Supreme Court in various judgments, that is in Procedural Limited, has observed that where the controversy is purely a legal one, and does not involve any disputed question of fact, but only question of law, then it should be decided by the High Court instead of disputing the interpretation of the ground potentially relative being available. However, at the same time, the Honorable Supreme Court laid down where the statute under which the action complaint of complaint or content a complete mechanism for the case of penalty. The person complaining a restriction should not be entertained. Simply, please judgment of the Honorable Supreme Court in case of PHR event execution so as held, paragraph 40. The law is with regard to entertaining a restriction on Article 226 of the Constitution in case of eligibility of ordinary remedy. It shall settle. In case of substantive conduct of the control, is not observed. Unfortunately, the High Court overlooked the settled law that the High Court will ordinarily not entertain a writ petition in Article 226 of the Constitution if an effective remedy is available to the aggrieved person, and that this rule applies with greater regard to matter involving recovery of taxes, cess, fees, other type of public money, and use of the bank and other financial institutions. In our view, while dealing with the petitions involving challenge to the actions taken for recovery of public due, etc., the High Court must keep in mind that the legislature elected by Parliament and the state legislature for recovery of the due are a court unto themselves, inasmuch they not only contain comprehensive procedures for recovery produced but also emphasis constitution of quasi-judicial bodies for reduction of the any grievance. Therefore, in all such cases, the High Court must insist that before availing remedy under Article 226 of the Constitution, a person must exhaust the remedy available under the relevant statute. While exercising the aforesaid view, we are conscious that the power conferred upon the High Court under Article 226 of the Constitution to issue any person or authority, including in appropriate cases and any government directions, orders or writ, including the five prerogative writs for the enforcement of any of the rights conferred by Part 3 or any other purpose, are very wide, and there is no express limitation on exercise of that power. But at the same time, we cannot be oblivious of the rules of self-imposed restraint involving by this court, whichever every High Court is bound to keep in view while exercising power under Article 226 of the Constitution. It is true that the rule of question of alternative remedy is a rule of discretion and not one of compulsion, but it is difficult for fathom any reason why the High Court would entertain a writ petition filed under Article 226 of the Constitution to pass interim order, ignoring the fact that the petitioner can avail effective alternative remedy by filing applications, appeals, revision, and particularly legislation contains a detailed mechanism for revision of the grievances. Paragraph 15 contains it could thus be seen that this court has clearly held that the High Court will ordinarily not entertain a writ petition under Article 226 of the Constitution if an effective remedy is available to the aggrieved person. It has been held that the rule applies with greater rigor in matter involving recovery of taxes, fees, other type of public money, and use of banks and other financial institutions. The court clearly observed that while dealing with the petitions involving challenge to the actions taken for recovery of public dues, etc., the High Court.
This is in respect of SURFACE. This is in respect of
Yes,
SURFACE.
but the case where the judgment was passed related to GST law. But there are other judgments of
No, the apex court does.
Yes, that was serviceable. But law laid down by the Honorable Supreme Court with regard to the agreeable of voltage regulation. And let me come to paragraph 617 also.
Yeah.
Next page. In case of authorized officer, State Bank of General Court and another Matthew Casey, this court was considering an appeal against an interim order passed by the High Court in a writ petition under Article 26 of the Constitution.
That is also under SURFACE.
Yes, no, it is correct.
SURFACE Act is slightly more rigorous.
No, that is there, but Lordship, I am placing this judgment because this was passed in case of a GST matter. My lordship, there are judgments of alternate bench also, which deliberately deals with alternative remedy part. If I can place that judgment also.
What do you say about the limitation aspect?
What's it that I'll individually, because every order has been dealt with. Just for example, in case of my landed and item 30, your lordship, invocation of the judgment of Supreme Court was there. Even though there was a limitation, but that is available. Recently, in case of income tax, Honorable Supreme Court, in case of consul's case, Supreme Court said that that fee is available to the government also. With regard to merit of the case, lordship allow, I can file response to the
We are hearing.
No,
We
lordship,
want to
because
address on the merit. It is
no, lordship, because they have only one petitioner has submitted his written. Others, they said that they
so
will
they have
submit.
submitted because he completed the argument. So you have to complete the argument.
Yes, lordship, and I can address. Regarding the alternative remedy, lordship, I want to place another judgment of this one, coordinate bench of this honorable court. As by the coordinate bench of this court. The elaborate judgment, all judgment, filed by the honorable Supreme Court, placed by the petitioner court, denied by the Supreme Court. Some of the daily product.
No appeal against this?
Lordship, no appeal. Lordship, this particular bench is cited two cases. Against that, lordship, no appeal has been taken. The judgment, lordship, all the judgment of honorable Supreme Court has been taken into.
No, but in respect of the factual metrics also argue.
Yes, lordship,
You'll
this
have
is
to address the court. If you want to segregate each order and then point out to the court on the issues which are considered by the
item
authority.
number 24. I understand I submitted some written synopsis.
No, no. See, you prepare a compilation, share it, and submit on how you want to speak, address on the merits of the case, that be the order. The legal issue of alternative remedy is one aspect.
That is my main argument.
That is one aspect.
That is one.
But assuming alternative remedy is rejected, they have raised certain issues on the jurisdiction of the authority in view of the fact that limitation is long over. But there is no intention, there is no material to show that there was suppression.
Even in case of jurisdiction point, lordship, that can be raised before the appellate authority.
Oh, that can be, but there is no bar.
No, yes, sir, there is no bar.
There is
There is
no
no,
bar.
there is, yes, sir, that is correct.
So therefore,
But even when there is an alternative, there are all questions of law or fact that can be raised before the appellate. That has been decided by our High Court also.
no, it can be raised, but we are saying it. Taxation is compulsory extraction of money.
Yes, that is.
Now that has to be as per the provision of law. Now, if the provision of law is very clear and you have crossed the limitations prescribed and the reasons given in the order does not support
that is up to
material.
Taken to consideration.
Sorry?
If that is so, then it is up to your lordship to.
I know it is up to me, but we are giving you an opportunity to deal with these orders and tell us that it is their submission is that each of these orders, where reading of this order reflects that there is no suppression or fraud or collision involved.
That is the submission of my answer to the petition. We have filed our affidavit in some cases. Case of just learned friend case.
This is item number?
Item number 4.
34, 24.
24.
Yes. Yeah.
Paragraph 5 of our FAQC, page 146. Page 146. With regard to the statement that in paragraph 14 of the petition, the ensuing respondent states that the petitioner certified that the impugned proposed notice dated 26/4/2021 is time barred, as extended period cannot be involved. Regarding the invocation of extended period of petition, the regime of self-assessment, the onus lies on the party to declare the taxable value, taxable service tax in their periodical tax-free sum. The party did not even file the periodical tax-free sum during the stated period. This stipulation of the taxable value by the state participant is followed by the department only after receipt of the expression from other source. Had it not been the date of receipt from the income tax department, the submission of valuable tax by the state notice would not have been rejected. The state notice equally suppressed the taxable value with intent to evade the payment of service tax. As such, demand was raised in the extended period. This is our explanation with regard to extended period of limit. Idea. One submission was made by under senior counsel that we cannot rely on the statement section 26 is going to that has been explained in the MP order. The order is not enough. Absolutely. Page 74 of the order in order. Paragraph 1.4.
Hmm? 1.4.
1.4. The scrutiny, the third party data provided by the income tax department, it appears that during the period from April 2015 to March 2016, an OCC provided service that received taxable amount of sufficient gross value. However, they have declared the gross value of service that is to be returned is lease. Therefore, service tax to the tune of rupees 2,55,54 lakhs or Indian essential and legitimate value of the service amounting to rupees 5 was specially paid by the state authority to the government of State, which they failed to pay. The same is required to be recovered from the provision of tax to the fifty of the federal tax, as amended by importing the extended period of federal tax. Paragraph 2. In response to the forward notice, the OTC filed a reply dated 25/9/2021. The state notice to make a growth the OTC is the provider of what contract mainly to the Indian derivative. B. The gross turnover as per exchange control is same as the income tax department report. And they provided per contract service to the Indian derivative. The gross amount of service
So, but where does it reflect?
it is their reply. The reply of the
No, you said it is there in the impugned order.
yes,
This is the reflection of the reply.
Yes, sir.
Show us how you can say that there is suppression reflected. Where is the finding of the authority?
No, no, okay. Because we received the data from the income tax department in form number 26A.
Hmm.
Thereafter, on analyzing that, notice was issued. Against that, they submitted their reply. That is reflecting the order in original law. Then they come to discussion and finding.
Hmm.
Paragraph 3, page 75.
Yes.
I have carefully gone through the impugned proposed notice dated 24. The defense replies dated 25/9/2021 of the state notice. I find that the thrust of the allegation in the impugned proposed notice dated 26/4/21 is that during the financial year 2015-16, the state notice was engaged in providing various flexible service under section 26(b)(2)(44) and section 65(b)(51) the Finance Act 1994. The service provided by the notice is neither falling under negative list nor covered under the mega exemption notification number 7. It is alleged that during the same period, the notice is collected with the flexible amount of rupees 17 crore 63,620. As per the IPR return provided by the income tax department, the state notice has not filed effective return of the same taxable value amounting to rupees 17 crore 56 lakh. Thereby, there was no payment of service tax to the tune of rupees 2 crore 54 lakh. According to the service tax liability society to determine applying the principle of execution as laid down in section 65B or 65B 61, 66B and 66B.
What are your services?
My lord, it is relating to conversion of the digital signal system in place of the old one. That the existing
This
paper.
is not covered under the
Yes, mega exemption, item number entry number 14A. My lord,
Where is it? Here?
In my written submission, I have submitted.
No, in the writ petition.
Writ petition, yes, that is.
Paragraph 2.4 case repeated. That is okay. To be examined whether the amount received by the state of the export service is acceptable under section 1994. For written submission made by the state of they have provided for state service to the same railway. Serial number 125. The table number are for which they receive both the same notice is all the work has been executed by the railway and are exempted by paragraph 14 of the Railway Notification. Paragraph 14
Where is the notification?
Notification paragraph page number 17, the writ petition I have extracted. Page number 17, paragraph number 12.
No.
The relevant
You have
provision.
not enclosed the notification.
Yes, I have.
Have you enclosed the notification?
Yes, today I have enclosed the exemption notification in the written argument. And here we have extracted here in paragraph 12. Paragraph 12, page number 17, the relevant provision notice 25 ST, dated having been bearing the subject matter the reproducible in excess of the power consumption of 7 services by way of construction.
Come to your submission, written submission. Where is it? Where is that notification? Not here.
My lord, in writ petition, page number 96. Start from 85 onwards. In writ petition, all the work orders and agreements, lease agreements has been.
We are asking you about mega notification, mega
Yes, ma'am.
exemption. Where is
Mega
it?
notification is attached in my today's written subjection.
Where in written?
Page number,
subsection?
page number 9.
9.
9. Entry number 14A.
Entry number
14A. Service by way of construction, erection, commissioning, or installation of original work pertaining to airport, port, or railways, including monorailway or metro rail.
What is construction, erection, or original works?
Original work, that means all original in relation to construction, erection, commissioning, or installation. Original works.
What
means
is original work?
In original form, not from the old repairing of the old one.
Service tech.
My lord, there is a definition of the original work in Rule 2A. My lord, at page 16 of the writ petition, I have reproduced the provision. At page 16.
Do you have these rules available with you?
Yes.
Service tax determination of value.
Yes, I have.
Give us a copy.
Rule 2A. I can read it. Explanation 1.
Yes.
Explanation 1, that is original work is defined.
All new construction. Yes.
In this case, we are erecting all the system, the signal system in new.
Yeah. Where is the impugned order? Page 76.
72.
In your reply, you did not furnish original work orders.
Yes, that is in before the adjudicating authority.
By way of a reply.
At the time of filing.
Then why this finding at page 78?
My lord,
3.6?
all documents has been provided before the adjudicating
No,
authority.
see the finding here, 3.6, page 78.
The said notice is not furnished with copies of the work order issued by the railways. So it is not possible to determine the work executed by the notice for the railway. My lord, here at the time filing our defense reply, page number 50, 51. May kindly be referred. We have already given intimation to the rail department. 51. At page number 50, annexure 3, we have given the reply to notice to the intimation to the department. Then again 51 also, the additional commissioner. Work order number 4 and so on, and railways and all these things in 2018. And again in 53 in 2020. Again in 54 page number. Everything has been acknowledged by the department authority.
Yes. prima facie it appears the materials were available before the authority.
Question may kindly be seen. In some items.
We have seen the discussion.
I am placing 3.6. That is provided to the railway. In paragraph 3.6.
Not furnished, but they pointed out page 52,
No, no,
53.
yes, they submitted some document with related to other item that has been discussed by the executive authority in the subsequent paragraph. For example, paragraph 3.7. They noticed they submitted that they had supplied machinery and equipment to the Indian Railway for which they received an amount of 1 crore 15 lakh.
Not provided any document.
Not provided any
But what are these documents at 52, 53 and all that?
I may be allowed to place the original record.
You go through, don't have to place it, you go through and tell us that these are not, these are seen from the original records or not seen from the original record. If you come to 50, page number 50 of the writ petition,
Desired by you.
no, you see the handwritten portion, document submitted,
Tenancy, work order.
work order.
2011.
Then next page also you will find
Yes, it is there.
now whether this work order pertains to that particular work or any further documents are necessary, this will be available from your record. Why did you submit the form 26AX?
My lord, it is income tax of the total that is available.
No, but you had submitted it.
Yes. Page 49, they have decided to ask to submit the page 49. Roman 7. Inviting reference to the subject also, service of the SSS at all statutory records and GST copy of the salas and all form 26A.
But they did not ask for work order.
In this case, they are no, subsequently they ask, then we provided.
That's it. You have to verify and revert back. Help. In each of these cases.
Individually, I'll prepare a note and
Tell us what documents were available, what is not. Because the first question would be suppression. Whether it amounts to suppression.
that is
Whether it amounts to, because most of the cases you are going beyond limit.
beyond that is it.
So that you can only do if you come to a conclusion that it amounts to suppression. Whether there is suppression in the first. There are these line of judgment that mere suppression is not sufficient.
That is held by Supreme Court.
Well, by the intention.
There must be element of reset of text, then only okay. But here in case of finance act procedure, it is a self-assessment procedure. Here, unless they file their return, it's difficult for the department to know about what they are.
No, quite right. But to arrive at a conclusion, prima facie, that there is suppression, you have to see it from their documents which are supplied. Now, here, there is a categorical finding that no work orders are supplied, but some documents show some work orders are there. I do not know what work
They have
order.
submitted some document that has been filled.
You have to verify it and tell us that whether the relevant work orders were before the assessing authority or not.
There is another authority. If suppose the executing authority committed some mistake or then then in case also they have to approve the appellate of that. That will not affect their remedy to avail of benefit. That is there. Most people order is very critical. Then Lordship, there is a provision for alternative, they have to avail. That's why Lordship.
Whether the jurisdiction is there or not, of the assessing, that jurisdiction will have to be decided on the material as to whether there was actually suppression of fraud pollution requiring reopening of these assessments beyond the limitation period. Number one. If there is no suppression, then there is no jurisdiction. If there is no jurisdiction, an alternative remedy way bar. Ordinarily not. You have to give the material little more specific. Each case. And then furnish it. Heard learned counsels for the party for a hearing on. Tell us.
So that it's there.
23rd January. 23rd January. There are 40 by family. I think it's time to get a photocopy on everything. Written arguments will like right. Yes, 23rd. Huh? Huh? 21, yes.
21 maybe.
Yes, item 21. We, since it involves similar issues, may be listed along with this item. 20 from 24 to 23.
Interim order, interim order.
Interim order passed earlier. What is the interim order?
Not to take possible. Not to take.
Why don't you pay some taxes?
We are not liable to pay the tax, so why should we?
If you're not liable, it will be refunded back.
Lordship, the department, once they take the money, they don't refund it.
Interim order passed earlier will continue till the next day. Yes.
Wait, please, Your Lordship.
Yes.
This is a matter relating to payment of compensation of land acquisition. Land were acquired in the year 2006, my lord. Annexure A is the acquisition land allotment order. Land was allotted to the APGCL for construction of small hydroelectric project, my lord, at Magdia. But if you, Lordship, may kindly go through the annexure B, page 524 of my read petition. I have made a bunch of paper, my lord, for convenience, lord. Please lay there.
Over and above this bunch of papers.
Yes, my lord, from this petition, my lord, for this
right.
petition is very,
Yes,
it is
give
there
it to
in
us.
the file, my lord.
You give it to us.
Well, it is there in the file.
Oh, it is there in the file.
Annexure B, my lord. Land allotment order.
Yes.
It is of 21/9/2006, my lord. First paragraph, last line, lordship will find the APGCL shall be liable to pay compensation to the affected people, if any. Then the next page also, lordship. Page
Yes.
25, 525.
Hmm.
There, my lord, last line, lordship will find hand over the possession of the land after payment of the compensation. Compensation has not been paid till date, my lord. There are so many correspondence, my lord, in the file. But lastly, this honorable court directed for a joint verification, my lord.
Hmm.
Joint verification was done, my joint verification by order dated 10/12/2023. There is an order from this honorable court for joint verification.
Any report submitted there?
Report submitted, lordship. Report submitted. We have filed an objection against that also. But today I am praying, my lord. This report says that land where they are affected people, my lord. Lordship will find page their affidavit, the report, my lord. The report 6, page 632, annexer R1.
This report is after the order of the court.
Court, yes.
6.
632 page.
There is no 632 here.
Affidavit.
Page number 6.
Huh?
There wasn't page. Yes, good. Hmm. Quickly.
Six six three. Lordship can look into the order dated 6/6/2024. Court order.
No, no. Where is the report? After
Report is page 663. In our affidavit in opposition, my lord, additional affidavit. Additional affidavit filed on, my lord, 12/10/2012, 3/2024.
it's not here.
Twelve part.
This thing from the lordship can go for it.
661. 661.
Second paragraph. Lordship.
आप वो फाइल में देखिए पेज नंबर। हाँ तो देखिए यहाँ पे नहीं है। हाँ देखिए। Yes.
Second paragraph, lordship, may kindly go.
Hmm. Yes. You don't have a copy.
In my copy. Second paragraph, my lord. On documentary inquiry, it was found that the land was allotted by the authority of KAC, Revenue Department, by so and so. Allotment order dated so and so, my lord, from an area so and so, my lord. And in the said land allotment order, the authority so and so land revenue department categorically stated that land compensation will have to be paid, have to be given by the APDCL to the public whenever it is applicable, inviting having patta land. But as per record, no compensation of the land had been given to the public whose land is a private patta land and got affected due to the construction of the land.
So there is a finding that no compensation. Then this is by KAC also.
The joint paper, Lordship, will look into order dated 6/6/2024.
6/6/2024.
Post order.
Yes.
And the potta, admittedly, Mother, pottas were issued after allotment of the order. So this matter, that point has not been clarified in the joint verification report. Why the pottas were issued after that, my lord, after allotment order, and how the peoples are affected. My lord,
No. And, who on whose submission this is recorded? The joint. Where is the order of joint verification?
order of joint verification, Lordship will look into it, order dated 1/8/2023.
One eight.
1/8. 11. My lord,
11
1/8. 1/8/2023.
Yes. Then after the joint verification report,
Joint verification was carried out.
there
but
is
in
no
the joint-
indication that pattas were issued.
My lord.
Then
But subsequently, my lord, that we are again planning to joint verification, my lord, along with the APDCL. But due to the inclement weather, we could not complete it. Now we are planning to complete it within the 31st December. My lord.
no. Why do you want two joint verification reports?
Well, that in that joint verification report, which was submitted, my lord, report was submitted, there is nothing how the peoples are affected. And if the peoples are not affected, my lord, and their lands were allotted subsequently to the allotment,
No. From where do you get this question that it was subsequently allotted?
my lord, that is the admitted fact, my lord.
Huh?
In the joint inspection report itself, my lord. Dates are there, my lord, where the lands were allotted. 6/6/3, my lord. Total, my lord, year of issue of pottas, my lord, column number, my lord, 4.
And when was the land allotted to AEGCL?
2006, my lord. And pottas were issued 7, 2020, 2021, like that. So the
Who issued this patta?
authority of Karyalam Autonomous
Then
So the petitioner claims the compensation on the basis of that, my lord. Whether they are entitled, my lord, and those lands were whether affected or not, my lord. That is the factual aspect required to be verified. It is admitted that thus, all the land pottas were issued, my lord, to the petitioners, my lord, subsequently, except 1 or 3, my lord. Annual patta, my lord.
The land was given in 2006.
Six, my lord. And if you lordship look into that column, my lord, quotas were issued, dates were given, my lord. Except, my lord,
Few.
a few, my lord, that serial number 39, 40, quotas were issued in 2003.
34, 35.
My lord, some of the petition, my lord, persons. So it is required to be verified whether they were affected persons or not. My lord. Only the land affected persons are required to be, can also get the compensation. And without, my lord, a proper verification report, my lord, on the basis of this report, my lord, the compensation, my lord, it is whether it is for them to grant the compensation.
So this objection was essentially raised by AGCL.
Yes. My lord, last paragraph of the finding, lordship. Just now, lordship has gone through 632 page, my lord. This is a finding. My lord, here it is clearly stated that finding.
Finding of the report.
Yes, finding of the report. Our joint verification. Our joint verification team had found that the following persons are the affected families. This is one thing. And another letter is there, my lord. It is annexed as, my lord, annexer 4, page 13, to the affidavit filed by the respondent number 3. Letter dated, my lord, 4/1/2020.
But when was the land allotted to AGCL?
2006.
2006.
My lord, the question is that they are, my lord, tribal people and their land is, my lord, ruled by the
But why the land was allotted after? Why pattas were issued after the land was allotted?
There is no patta system in, my lord, that area. In tribal area, my lord.
Maybe.
There is, my lord, they use the land and patta is allotted after if necessary. There is a letter from the, my lord, assistant revenue officer that they are governed by the traditional, my lord, land rules, customary rules, my lord, and that is why they do not have the patta. There is a letter also will find, letter dated 4/1/2014, issued by the assistant revenue officer.
Page number
It is annexed as annexer 4
of
affidavit filed by the respondent number 3.
annexer 4.
Affidavit filed by the respondent number 3. Page are, my lord, page shown as page 13, my lord.
Annexer 4. Letter dated 4/1.
4/1/2014.
What does it say?
It says that their land are covered by customary laws, my lord, and pattas are issued whenever it is necessary, my lord. Last portion, lordship will find. Moreover, it is to be noted here that some villagers of the above mentioned villages are occupying that area since the time immemorial for establishment of new villages and zoom cultivation. The land, especially in the hilly area, are owned by the.
Zoom cultivation, why will patta be issued?
Yes, my lord, but they are using the land, they are affected people.
Zoom cultivation, you are not affected. You cultivate for one season, go to the next place. How are you affected?
No, that is not. But they have cultivated the area. They established new villages, my lord. It is said cultivated and new villages were established there, my lord. They and
You show us.
report says that it is the
From the
their report says, lordship, that they are affected people. Report itself says. Why I have to prove? It is a joint verification by them. This report has been signed by.
No, madam, report has proved, but your pattas were issued after
yes,
the allotment of the land in AGCL. Now the question is, why was it issued? According to you, these pattas are issued on as and when necessary, otherwise land belongs to the headman.
Yes, it is as per customary law.
Show us that law. Show us that law so that we can pass an order in your favor. If
Then
that is the law. Huh?
this is a letter by the
No, maybe
revenue
that-
authority, not by us, my lord.
That's all right,
is
but you are representing them as a council, so assist the court in understanding what is the law. If the customary law says so, then perhaps you may have a case for.
Yes, my lord. And this letter is issued by the revenue authority itself, my lord.
No, letters may be issued,
Yes.
but whether the law itself,
Whether the authority has issued this letter wrongly,
we don't know. It is for you to support your contention.
then given some time.
You come back with your customary law and tell us what is the procedure. But Mr. Sutia, you carry a joint verification, your people carry it out, then you issue a patta after the allotment. No, all right. At the time of joint verification, the report says people are affected.
How they are affected?
What do you mean how they are affected? Land is given them, they are affected. How will you get the report now? What do you mean how?
That regarding the how the people are affected of that point, and whether the after whether they are occupying the land after allotment of the
How will you find out in a joint verification? How will you find out? If it is allotted to the, is it not bounded now? Has it not been handed over to the? No. The land which is identified in respect of which the compensation is.
only whether the time of delivery
Has it been delivered or not? Are you in possession now? Have you taken delivery of the land?
Just I'm taking to the report, my lord. My lord, the report says that the effective land is 94 bigha, 94 bigha, 1 kata 4 lesa. And all the persons, they have total 1024 bigha. They kindly see, my lord, from the first one, my lord, that page 663, Hemari Rongpar has Patta was issued on 11/12/2007. Total land under his possession is 10 bigha, and total land effective has been shown as 3 kata 7 less, not the entire land, as per the report. Now the Honorable Court has directed us, the authorities, to have a joint verification and to have an inquiry under what circumstances the patta was issued.
By which order?
By 6/6.
6/6.
Yes.
24.
Plus 6/6/24. Kindly see one. Mr. So-and-so, Semi Council so-and-so, and Council for Caribbean Law shall receive instruction as to the manner in which the beneficiaries are identified in the joint verification.
How much time do you require for this verification? 31st January. There is an order, judicial order. Let us see what comes up.
My lord.
And meanwhile, you place the law with regard to land holding.
Customary law.
This is the 6th schedule land, isn't it?
Yes, six schedule.
Right, heard current counsel to the parties by an earlier order dated 6/6/2024. No, sorry. Where is the first order for joint verification? 1/8/2023. This court had directed the officials of Karbi Anglong Autonomous Council to carry out a joint verification with the authorities of APGCL as well as the writ petitioners. Stop. It says joint verification was carried out and by a report. And the report of the joint verification was placed before the court by way of an affidavit. So it says joint verification clearly reflects number of persons stated to have been affected by the land acquired for the purposes of projects of AEGCL. Stop. Subsequently, upon perusal of the state report, this court by order dated 6/6/2024 put a query to the respondents as to the manner in which the beneficiaries were identified in the joint verification report available as Annexure R1 to the affidavit filed by KAAC authorities on 12/3/2024, and also as to why the pattas came to be issued to some of the beneficiaries against the land so acquired after the land were stated after the lands were stated to have been acquired. Stop. This joint verification was directed to be conducted. However, it is submitted by the Standing Council KAAC that because of inclement weather, the said joint verification could not be carried out immediately after the order was issued. However, now the weather climate is weather is conducive for carrying out joint verification in this hilly terrain, and therefore the authorities have initiated the steps to carry out the joint verification. Stop. Learned Council, Standing Council, KAC submits that the verification will be conducted during the month of January. He therefore,
Petitioner may be allowed to participate.
yes, he therefore submits that the matter be listed after, in the month of February, enabling them to file a comprehensive report of the joint, after the joint verification. Stop. Para, in view of the orders referred to above, and after due perusal of the earlier joint verification report from this court, therefore permits the respondent KAC to initiate a joint verification report and examine the extent of damages claimed to have been suffered by the landholders, including the writ petitioner, and thereafter finalize to proceed the manner of payment of compensation due, if any. Stop. This joint verification will be conducted in the presence of the AEDCL Council, AEDCL official, APGCL officials, as well as the writ petitioners and the other affected landholders. Let the matter be listed on 5th of February, 13, 12 February, 12 February. List accordingly.
Are similar to what has been argued, because this is also Finance Act matter. So what I was saying that this matter may also be fixed on 23rd of January and as part heard matter, because it was already heard in length. So on 23rd January.
What? This is about akin to which matter?
The series matter.
Series matter.
Series matter. Finance Act.
Yes. Okay. Then item 35 also connected, but we have not heard you.
Lordship, the day before yesterday, the hearing was done. Lordship at length. Lordship, I was fixed.
Then why did you not argue at the time? When
Lordship, that point of time it was missed.
it is submitted that item 35. There is a similar issues which have been heard in respect of the writ petition. Bunch of writ petitions where the lead case is WPC 3065 of 2020. According, let the writ petition be also listed along with the state writ petition. On which date?
23rd January.
23rd.
3rd.
23rd January.
Much obliged.
Yes.
Please, Your Lordship. Lordship, this matter was heard at length by a coordinate bench, and there is an order to that effect, Lordship. Lordship, may kindly peruse the order dated 10/9/2024.
Is part heard before any other bench? Part heard.
It is not kept as part heard, it was heard, Lordship. I'm just referring to that order, Lordship. 10/9/2024, Lordship.
Thereafter, it was listed before arbitration.
Yes, Lordship.
They did not mention this.
Lordship, actually,
The
this,
last order.
Lordship, I'm not saying that it is kept as part heard, Lordship. It was heard at length by a board
It's
and
not part heard. It's not
no,
part.
Lordship.
Then why are you making this submission?
Lordship, just I wanted to point out one.
How is it relevant?
Lordship, they were to apprise as
Unless
to
it is a part heard matter. How is it relevant?
Lordship. However, a back order is relevant, Lordship. They have to
The
apprise.
order is relevant for what it reflects.
Yes, Lordship.
Does it reflect anything?
Yes,
More.
Lordship, that they shall apprise this court as to when the state authority is paying the amount to the district administration.
That is okay, but does it reflect that it was heard in length?
No, Lordship.
Then why did you make this up? Yes, what do you have to say? You have completed your argument.
Lordship, at that point of time, it was heard, Lordship.
Then very well, you want to submit written arguments, you submit. What about the respondent?
This time we had not heard. The time we had not heard.
You are not heard.
We had not heard.
That's right. So you can argue your matter.
Chapter 9. Item number
Step 9.
Yes, Lordship. WPP
7173.
Yes, Lordship.
Yes.
Lordship, we are before this court. Lordship, in this petition, we are seeking compensation for causing degradation to our land by Coal India Limited due to open cast mining, Lordship. There were several rounds of litigation before this, and the amount of compensation was calculated, which amounts to around 2 crore 98 lakhs, Lordship.
Yes. Who are you?
I'm the petitioner, Lordship. I'm the people who were staying in that area, and our lands, our cultivable lands, were degraded because of open cast mining done by them.
Then
Lordship, may kindly peruse page number 58. It is a report of the subdivisional agricultural officer, Lordship, showing that our land was degraded.
no, you belong to the land. Where do you stay there? The land belongs to you, or you are in this. It's under your possession. What page?
We have come here as a society, Lordship. We have come here as a society.
But you still have to give some evidence to show that this land belongs to you. Some documents to show that. Where are those? Nothing is there. Yes, madam. Nothing is there.
Also, in the earlier round of litigations, quite a few times it has been mentioned, Lordship. We have not given the details probably in this.
Here you are now before this court in this writ petition, and your prayers are very specific.
Yes, sir.
So, in order to support your prayer, you must show that you are entitled to this claim.
Uh,
We dismiss or you withdraw.
Lordship, may kindly take it up after some time.
After vacation in January, at reopening. Reopening after reopening.
Okay. Allow me to item number 10.
Yes, both the matters.
This matter regarding extension of one room at the downtown stadium under the Dumduma Town Committee. And for better understanding, may I place my lord page 21 is a drawing that can be, I can place properly. Page 21 of the writ petition.
No, who are you in the first petition?
My lord, I am the tenant under the Dumduma Town Committee in connection with one stall, roadside stall, number 1, and that is at the stadium. Dumduma, there is a stadium, and under there, one stall is there that it belongs to me. And in the page 21, this drawing would clarify everything.
Page number?
21 of the writ petition.
21.
Yes. The existing road middle in the middle portion, my lord. Existing roadside stall number 1 belongs to me. Means I am the tenant. So, my lord, the fact goes like that previously, my lord, in the year 2009, I applied for the extension of the back portion, my lord, the proposed extension. That is actually a path, underway path. And I prayed before the Dunduma town committee to extension of this part, that drawing page 21, proposed extension. So it was thereafter, my lord, allotted to me by virtue of the order 9 January 2009, my lord. Page 22. And it was allotted, and I was directed to give 1,05,000 as a security amount and to construct the back portion. The construction part was upon me, but the problem was that I was not at that time good physical health and suffering from illness. For that, I could not deposit the security deposit as well as the proposed extension, my lord, because that amount was not with me. Therefore, I made one application for extension of time. And the problem was that as it is a Dumduma town committee, so the board meeting was to be held and decision was to be taken, but it was not taken. Subsequently, however, it is learned that the security amount was reduced to 75,000. But it is an admitted fact that I could not at that time deposit that amount, and I sought extension, but that was not subsequently, board meeting was not there. Therefore, that proposal was remained as it is, like, my lord. Thereafter, my lord, in the year 2000, my lord, may kindly come to page 29. Annexure 6. And type copy is at page 28. So the private respondent was, he also played to extend his shop. And his shop is at, my lord, may so that can be seen in the left portion of the drawing. Dr. B.K. Hazarika chamber. So he applied to extend this portion behind my stall as his part, my lord. And surprisingly, without giving any so-called notice or anything, it was allotted, my lord. So when I prayed before the board committee under the RTI and filed one application before it and under RTI, some documents were given, and these documents I have already placing, my lord, and page 30, annexure 7.
Yeah.
These are the notes. It says that আবেদনকাৰী বিচৰা মাটি দুখৰ পূৰ্বতে 70,000 টকা জিতেন ডেকাক আবণ্টন দিয়া আছে, কিন্তু এই আবণ্টনৰ বিপৰীতে দিবলগীয়া প্ৰতিপুতি ধন আজি পৰ্যন্ত দিয়া নাই। গতিকে এই বিষয়টো নিষ্পত্তি কৰাৰ পাছত আবেদনকাৰী means that private respondent, আবেদন সন্দৰ্ভত ব্যৱস্থা গ্ৰহণ কৰিব পৰা যায়। So my specific allegation is that in spite of this, no so-cause was given to me, neither I have been given any opportunity to submit that amount or make the construction. The town committee has allotted the said portion, vacant portion, to the.
Under what rules or provisions are there?
My lord, if we see the Assam Municipal Act, page 43 is relevant. Section 43, sorry, page 40.
Section
43 of Assam Municipal Act, 1956. Ordinary and special meeting.
Yeah.
May I read, my lord?
Yeah.
The commissioner shall meet for the transaction of business at their office at least once in every month, and as often as the meeting shall be called by the chairman or in his absence by the vice chairman. If there is no business to be laid before the commissioner at the monthly meeting, the chairman shall, instead of calling the meeting, give notice to the fact commissioner 3 days before the recent. And any, my lord, for deciding any decision or query or any application, this is a compulsory, my lord, mandate. At my period, it was not done, but when the application given by the private respondent, they did it without giving me any notice. Or the thing is that, my lord, when I made the application under the RTI, no resolution was given or no, my lord, decision or what I can call minutes of meeting was given to me saying that there was a meeting or anything giving the portion to the private respondent. Subsection 2, meetings resolution, challenge to validity of. Section 45, manner of deciding questions. 46, quorum. These are to be there before deciding anything. But that was not done.
So these for why are you referring legal meeting?
Well, for any general, ordinary or special meeting, not just a special meeting, for taking any decision, there must be a meeting, there must be a quorum, there must be a minutes of meeting. Now, record was called for, and the record is with the government advocate. And when I was allowed to go through the record, although they have filed the affidavit in opposition, but those were not, those resolution or minutes of meeting were not annexed. But records are there. Also, it shows that one minutes of meeting is there. I have seen that only the chairman has signed. No other members are there. But in regard to the other meeting, there are some signatures. So that is also one important point, my lord. So the point
So your application was, according to you, never rejected.
My lord, that is correct.
Rather, it was never placed or discussed upon.
That can be also
Is
the
the
government advocate can
interpretation
place
that
it.
you want to give. And the private respondent's application was allowed.
My lord, the initial application for extension was granted. The extension of time was not, my lord. Anything was not done. That is my one of the objections. So the record would reveal the thing.
What do you say? Who's for the town committee? You were there. Who's for the town committee?
Earlier,
in our affidavit, we have stated my before. So what is the affidavit filed by the respondent number 2?
with no annexer. The annexer should be.
Yeah.
Our document kindly goes to the paragraph number 5 of this affidavit.
No, affidavit filed by
Respondent number 2. Prior to that document, kindly goes to the paragraph 4. Earlier, room number 1 was allotted to the petition. And
he is still there.
My learned friend is saying
Earlier,
that I will not.
as because he said earlier.
Let him complete fast, Lord. Then I will type that.
I'm just clarifying, my lord. Sorry. As because he used earlier.
Yeah.
My lord, paragraph number 4, Lordship, the rent was deposited by the petitioner. And since my lord,
No. He prepared that he extension not complete. And then the private respondent.
You are asked to pay the amount, total amount and
Right.
other things, my lord.
Now, initially when the agreement, when deal was entered in, there is the order of the resolution of the say that he is as per the accepted
Lordship.
the report.
Lordship, my kindly goes to the repetition. Annex 4, page 22. Lord. Initially, my lord, that the permission was granted to extension of the room, Lordship. And the petitioner was asked to deposit, Lordship,
No, we see that. What we want to know from you is from your record, prior to this is an order communicating a decision of the town committee. Do you have that decision of the town committee in the records?
That resolution was not here, Lordship, that only the order copy was.
So he is that the cancellation is that by only by the chairman.
No, my lord, that there was a meeting, Lordship. So that is there.
So meeting, but it says that two signature of the other forum is not. So in that context, we wanted to see the original order by which the resolution was adopted.
Well, Lordship, that meeting copy of the order copy is there. My lord, whether the attendance register is not.
It must be there in your file somewhere.
Well, in the report, my lord, it is not. Only, my lord, that order copy are.
No, this order copy communicates a decision of the committee, isn't it?
Lordship.
So the committee, according to the provisions, must conduct its meeting, which has to be headed by the chairman and other members are there.
I thought that
There will have to be a minute.
a minute is there.
No, the original one, 2009.
This is 2016. Minute is there.
You call for that record and see. If that original meeting contains all the procedure, then subsequent meeting doesn't contain, then it is contrary to the provision.
When that my lord that he was asked several times to deposit that amount.
No, quite all
That it
right.
was-
What
and
he is
only
arguing,
because of my lord not depositing the amount, my lord, it was carried.
what he is arguing is that it is the chairman who doesn't like him. And the chairman has,
7 years they are waiting. Lord. After 7 years, it has been cancelled.
then what were you doing for 7 years?
Hello, Rick. First of all, it is not a room. It is an open space. And I was to, it is on
Whatever
my
it may be,
application.
but you asked for extension, they granted you, you did not deposit.
Initial, that is my mistake, I agree to that. But subsequent, when I placed before the committee to extend some time to, so that I could construct and deposit the amount, that was not done. But at the time of the private response, it was willingly done.
No, not this one, 2009 one. No, you are not connected with 2009. That will be available with the government. That is what we want to see.
2016, my lord, this, my lord, the allotment has been cancelled. Then, my lord, we have been allotted.
No, that's right. But he is questioning the cancellation itself. He is saying that the meeting was not held as per the provision of law. Therefore, we wanted to see how the meeting was held while the lease was granted to him.
The notice was given prior to the cancellation of.
So he is not on any of these. His only concern is that the provisions are not fulfilled. Can you get it next week?
Next week, my lord, have to bring from the Dumduma lot. It is that time.
Then January?
After the vacation.
January 23rd.
Well,
23rd January. Heard councils for the parties.
We cannot.
The records containing the minutes of the meeting, whereby the original order granting the deeds to the petitioner by communication dated 9/1/2009 was adopted by the Dumduma Town Committee is required to be perused, is required to be placed before the court. Here are Mr. J. Hendick, the counsel appearing to the committee, submits that we could call for the records and have the same placed before the court on the next date, as the relevant records are not available. As the relevant records containing relevant records relating to that period is not available. List accordingly on Mr. D.K. Nath for the petitioner, Mr. A. Hendick for Tumtuma Town Committee, Mr. Town for 5. List on 23rd. Yes.
Okay.
Yes.
Well, these are, I think, well, this subject matters are different, but then the only relation is the land grabbing cases, man. Land grabbing, under the cases of the Land Grabbing Act, my lord. Now, my lord, before I start, my lord, there's a judgment of this honorable court, my lord, which says, my lord, that 226 is not maintainable, which has come subsequently after filing of this, and it has to be converted to 27. I must point it out first to your lordship, my lord, because it was filed under 226.
Has it been converted? No.
My lord?
Has it been converted?
No, my lord, in this case, it's not been converted. That particular case was converted, my lord. Where I was on the council, my lord. And my lord, I had filed that application with this honorable court and finally held, my lord, that this is to be converted. Now, this application is yet to be converted. And my lord,
then you file an application in terms of this.
may not be necessary if the PepsiCo judgment. But they not be a PepsiCo pays the
So nomenclature should not be, but if the rule says so.
no,
Yeah, it's not the rules. It's not the rule, man.
It should be for appeal. Since there is no appellate authority, that's why they.
If there is no appellate authority, then it has 27.
Well, it was filed initially it was being filed at 226. So I also filed that, but subsequently this honorable court has done. Ordinarily, madam.
We are called upon to examine the correctness of a tribunal.
Yes, sir.
So therefore, the scope of examination is like a revisional.
No, here the basic here the basic issue was whether this is a personal designator or not. That this honorable court has held. This is a court. Therefore, but this was converted so much by this honorable court. That lordship will see the page last page. Ratio is directed to raise the petition is under 227 matter, and then may take new list matter for here. Page 25.
So this writ petition is still pending.
This is pending. Now it has been converted to 227. Now it's similar as 227 has been raised. That particular case. WPC number 558/2024, where this judgment was passed, that has been converted to 227. That is pending.
You are for?
Okay. Item number 40.
But the land are different, madam. Totally different. Madam.
The rule says so.
In fact, there was a direction, my lord, on 9/6, my lord, asking me the government to obtain instructions as to why the tribunal has not been constituted. And Mr. D. Mojumdar, additional advocate general, he appeared, and 9/6/2024, that order. Sorry, 6/6.
Yes.
Unwillingness of taking of the food by the subscribed party, according to the sector, that they are unwilling to get the food, so that the tribunal is constituted of that. Oral instruction.
What is the parameters required?
That just told
No, for tribunal.
Yes.
This tribunal of how many members?
My lord, appeal, my lord, the appellate tribunal. Section. No, in the special court is there. Appellate authority.
Actually, conversion need not be there. We can clarify that we are examining this from the standpoint of 227. So
that's one. That's one.
Take care.
That's one. Take.
But we'll have to take it up in January. Please take it in the month of January. It will be picked by the registrar.
So the lordship is converting it, or I should file an application?
We're not saying anything because you see, we only have to clarify that although filed under 226, in view of the fact that this is the order of the tribunal is challenged, our scope is limited to 27. That's all.
That's all.
Whether it is registered, not registered, we both the matters. Both the matters. These matters again for hearing on a date to be fixed by the way. Meanwhile, the state government will apprise the court regarding the up-to-date instruction as to the steps taken for setting up of a appellate authority. What is that? Appellate authority. Appellate tribunal. Under the Assam
Land Grabbing Act.
Land Grabbing.
Assam
Assam
Land Grabbing Act, Prohibition Act 2010, madam.
Land Grabbing Prohibition Act. Land Grabbing within bracket
Prohibition
Act
2010.
2010. Appellate authority. Right. Please record it. Yes. What is this?
This is the matter filed by the Axis Bank against the direction issued by the ED authorities.
Issued by the?
ED, Enforcement Directorate, to debit the increased amounts in their bank to the authority. Because under the PMLA, once there is a provisional attachment, it goes to the adjudicating authority, and adjudicating authority having finalized that under the provisions of the law, that has to be transferred to the state. So we have issued them a notice to kindly transfer it. That has not been done, and that is a. And in fact, in a similar case,
There is a stay.
there is a state. In a similar case, Axis Bank. In fact, this case which I am referring to, it arises out of the same PS case. There are multiple agencies who are involved. And here, the single judge has directed to come. Same judge who has granted this case. I may take your lordship to the 11th
No, but there is no petitioner. If there happens, what can be done?
This one.
None appears for the petitioner involved. Mr. Architect already appears to be
Enforcement Director.
enforcement director. Placed according to the month of January. Yes.
Your Lordship, I'm government employee working as a community health officer at Amtola in the district of Lakshmipur, Lordship. But while I was posted at Guwahati, Lordship, during that time, Lordship, I have availing the number of loans from the state loan, Lordship, Panjabari Bank. Initially, Lordship 4 lakh, thereafter 80,000, and again 50,000 online mode. And accordingly, Lordship, into their affidavit has been filed by the Learned Council Respondent Bank, Lord, wherein categorically mentioned that Lordship that I have availing the number of loan, Lordship, and accordingly into their paragraph, Lordship, paragraph number 7, your Lordship. This time, page number 83, Lord. Wherein categorically mentioned that Lordship on 1,07,000 has been credited into the into bank account, loan account number, Lordship. Thereafter 33,400, again 16,500, and again 1,000. But it is mistakenly maybe 1,000. It is 10,000, Lordship. Almost 1,65,900. Moreover, Lordship, apart from this amount, Lordship, into their affidavit, Lordship, that is clearly mentioned that, Lordship, Annex A, page number 89, Lordship, kindly be paid, Lordship, that my loan amount, loan installment has been deducted, Lordship, into page number, Lordship, 115, as well as 117, wherein categorically mentioned that, Lordship, that 7,500 rupees has been deducted from my account, Lordship. Almost, Lordship, 1 year, 7 months, Lordship, I have duly been paid, Lordship. And apart from this amount, Lordship, again 1,65,000 I have paid. And there in subsequent stage, Lordship, my salary has been deducted by the respondent bank without prior notice, Lord. It is absolutely right that I have a bound to repay the outstanding amount to
How
the
much are
bank.
you going to pay?
I admit that fact,
How
Your Lord.
much? What's the outstanding amount?
Only there, first loan he has taken 4 lakhs, madam. And thereafter another 80,000 he has taken. 80,000 was taken by Unolo. Then, my lord, there.
Tell us now what is the amount recoverable from him?
Well, actually, my lord, what happened that now 3 accounts is different. Yeah.
Your
Now
salary account, which is your salary account?
Salary account and the loan account is different. Although the same lordship, wherein the link between the salary account and loan account, for which lordship from my salary account lordship, they has whimsically deducted.
How many accounts do you have?
There are two number of account lordship. One is the loan account must be when I availing the loan, I must have open the account, that is mandatory lordship. But salary account into their bank lordship. But in the meantime, lordship,
For all the 3 loans, there is only 1 loan account or 3 loan accounts.
3 loan.
Loan account.
Yes.
Plus 1 salary account.
Salary account is the different account. But when lordship, I have availing loan, another loan
We are
account
asking
also
you
have
how
been
many
opened.
loans have you availed of?
Yes.
How many loans?
3 number of loans.
3 numbers.
Yes.
So for 1 loan, there will be 1 loan account.
One loan account, but subsequent stage I have availing 2 number of loan. Subsequent stage from this salary account. Salary.
My lord, what happened is, my lord, when he was availed that second one loan, my lord, then he was irregular of the EMI paying. Then what happened? We approached before the national law order. He signed in the agreement. We settled that all those things, my lord, in the 3 lakhs, my lord. For kindly for a moment, my lord, 143, my lord, for my reply, my lord. Here he say upfront fees of 10,000 has deposited, and the my lord, remaining amount should be paid on 8/12/23. Thereafter also he was not paid anything. Then again we have given an option, my lord. He has taken a personal loan 50,000 again, my lord. That was also EMI, my lord. His declaration is there, my lord, page 151, my lord. He himself signed, my lord, to auto debit 8,500, my lord. Page 151. Now, my lord, what happened? He is not paying anything, my lord. Now, my lord, whatever the amount is deposited, my lord, in that particular account, my lord, then it will be auto adjust, my lord. It is a auto system there, my lord. And I have materially statement, my lord, that, my lord.
Now, what is the outstanding amount?
Lordship, it may be subsequent stage, Lordship, day by day amount has been increased. That is, can be produced, Lordship, the personal loan agreement. That is very much important, Lordship. When we entered into an agreement, Lordship, between the bank, one page 147 into their affidavit, Lord. Except annex, can be produced. In this loan agreement, Lord, in para number 3, that is important, Lord. Can be the borrower expressly agreed and undertake to notify the bank in writing of any circumstances affecting the correctness of any of the particulars set forth in his her application immediately after the occurrence thereof. Then another para, your lordship, 6, para number 6. The bank shall be entitled to increase or decrease the amount as well as the number of EMI which compromise of principal and interest and its sole discretion either on account of change in interest rate of otherwise, and the borrower undertake to pay EMI as determined by the bank till the time of entire loan together with interest and other unpaid penalty, cost, charge and expense in repeat. That is, I have categorically mentioned and signed. I signed the agreement that I will pay the interest if any default amount has remaining to pay. That is, but in such agreement, lordship, in para number 9, 1 categorically mentioned that what is the condition if loan account has been being default, lordship. That is the another in this regard, para number 11, that is stated that the borrower hereby further agreed to that as precondition of the loan advance given to him by the bank, that in case of default in repayment of the loan advance or in repayment of the interest thereon, or any of the agreed installment of the loan on due date, or in maintaining the outstanding amount within the drawing power at any point of time, the bank and the Reserve Bank of India will have unqualified right to disclose or publish
What,
these
what
are
is
named.
your, what is your prayer now? What is the prayer that you are making before the court?
Not to whimsically deduct, Lordship. That is the RBI stated, RBI guidelines is there, Lordship.
Where is the RBI guideline?
Yes, Lordship. There RBI guideline is there, Lordship. That moreover, Lordship, unable
So what
Supreme Court.
whimsically means they are deducting as per you ask for the account statement. How they are deducting, you will get the calculation at which rate they are, what interest they
But
are.
earlier, your Lordship order, they have submitted the document by supporting this affidavit, Lordship.
Then,
All this.
then what you have taken a loan, you have to repay it. You are not
It is
denying
my
it.
duty bound, but your Lordship, the Supreme Court clearly mentioned that the unfair practice is not a place in India which is civilized society.
What is
A
the
rule is
unfair,
governed by law,
what is
Lord.
the unfair practice? What is the unfair practice?
Lordship, whimsically deducted. My entire loan installment salary has been credited into their bank, Lordship. Presently, 2,50,000 has been credited. I have no option that I have an account into their bank only because of that they have deducted salary account.
They will
But in any point of time, Lordship, I may be, my service will be terminated due to the financial problem. I cannot survive. I am working as a community health officer.
You change your bank account to take it
Lord,
to some
yes,
different
that is why, Lordship. Kindly, Lordship. Lordship, when I sent my account, Lordship, the bank has issued notice to my authority, Lordship, then stated that
So what is the amount that you are now required to pay?
My lord,
according to you?
page 138, my lord. Is my 3 lakhs, 3 lakhs 151 rupees, one loan, my lord. Page 1, I have annexed here the statement, statement 138, my lord, page.
138.
Yes, lord.
Yes.
Page, my lord, balance
3
amount.
lakh 151.
My lord.
3 lakh 151.
Yes, lord. And another remaining is, my lord, page 141, my lord.
Yes.
That is, my lord, 31,372. That much is he had to, my lord, recover from his loan.
So
and my lord,
3 lakhs plus 31,000.
My lord.
That you repay that amount.
Lordship, I cannot dispute it. I am bound to pay. It's my duty bound. I will pay. But Lordship, disputed only because that day by day interest has been increased and my salary has been frozen, Lordship. Still now, Lordship, kindly pay this.
No,
If
what order can the court give?
Lordship, kindly be paid, Lordship. One complaint case has been filed against me, Lordship. That is, Lordship, Annexer A, page number 53, Lordship. Kindly be paid, Lordship. Page number 53, Lordship. One complaint case has been going on before the learned CJM at Kamrup, Lordship. I have duly participated in that complaint case, Lordship. Another day, they have paid that, Lordship. The case is going on. In the meantime, how my salary account has been frozen, I have no option. I have an account into their bank only because of that. They have frozen my account, your Lordship.
You have taken a loan, you repay the loan
Lordship,
through
the
other
procedure
sources.
is going on, Lordship.
You repay the loan through other sources.
Your Lordship, Honorable Supreme Court Lordship clearly mentioned that. Kindly be paid, your Lordship.
Yes.
Yes, Lord. The recovery of debt due to bank and financial institution.
You give the citation, they'll take up the copy.
Lordship, 2007, Lordship.
You have taken a loan. You are not willing to repay it.
I am willing to repay, but
tell us
Lordship,
how much time
procedure
you
ought to have been conducted. I may be given opportunity, Lordship.
How much opportunity you want? What opportunity you want?
At least 3 months I may be given. I will compromise, but till then, Lordship, my account is to be open, Lordship.
3 months to compromise. No, 3 months if you say that in equal
Yes,
installment.
within 3 months I will pay. I will
Equal
discuss
installment.
with the bank authority.
Equal installments.
In 3 different installment, Lord.
In 3 equal installments.
Yes, Lord.
All right.
Yes.
My lord, earlier also in
You get your instructions. In 3 months he wants to pay equal installments. What installment did you?
Earlier occasions also what happened, my lord? He paid. Earlier occasion when the case was
Forget earlier occasion. Now he has offered before the court. You go and inquire and find out what are the 3 installments that you require. You tell us.
We have no objection, my lord.
Don't you tell? Why don't you understand what is the 3 installment figures that you want? Merely saying 3 installment will not do. You have to give the figures.
Yes.
So you get your instructions and tell us on Monday, Tuesday, Wednesday, whatever date is there.
Absolutely.
18th.
And Lordship clearly indicated that how much I remain.
Let him get all this information. Please don't wait it. Learned counsel for the bank will apprise the learned counsel for the petitioner has offered to clear the outstanding amounts on the basis of or in respect of the two loans which he has availed of from the respondent bank. On such submission, counsel for the respondent will apprise the court the quantum of the amounts to be paid in 3 equal installments by the next 8 weeks.
My name is I am Keita.
Mr. K. Das for the bank appears for the counsel for the bank. Please take a note 80.
Deep.